Right now, thousands of people across the United States are preparing to file their N-400, their application for naturalization. They've waited 3 years, some have waited 5. They've built their lives here, they've paid their taxes, they've followed every rule. And then USCIS sends back their application, rejected, fee not returned, not because they did anything wrong with their residency, not because of a criminal issue, but because of one date, one number, one misunderstanding about a rule that most people, and honestly even some consultants, get wrong. Today I'm going to break down the 4 most dangerous mistakes people are making right now in 2026 when it comes to U.S. citizenship. Mistakes that are costing people months, sometimes years, and in some cases, their entire immigration future. Stay with me through this entire video because mistake number 4 is the one most people don't find out about until it's already too late. My name is Raymond Crivello. I'm a senior immigration analyst and consultant, and on this channel, I break down complex immigration developments into clear, fact-based analysis you can actually understand. No rumors, no panic, just policy, data, and strategy. Before we go further, I am not your attorney, and this content is for educational and informational purposes only. Every immigration case is different, and I always encourage you to consult with a licensed immigration attorney about your specific situation. What I give you here is analysis and education. What your attorney gives you is legal advice. Both matter. Now, let's get into it. The first mistake is also the most common, and it's a pure math problem. Here's what happens. You've been a lawful permanent resident for 3 years. Maybe you're married to a U.S. citizen, or 5 years if you came through a different path. You think, okay, my anniversary is coming up, let me get my application ready. And you file. USCIS rejects it. Why? Because of a rule called the 90-day early filing rule. Under this rule, you are permitted to submit your N-400 up to 90 days before you meet your continuous residence requirement. Not 91 days, not 95 days, 90 days. If you file even 1 day too early, your application gets rejected, and your filing fee of $760 or more does not come back to you. USCIS actually has a calculator on their website to help you determine the exact earliest date you can file. Most people don't use it. They count backward on their own calendar, they miscalculate by a few days, and the result is a rejection notice and a financial loss. The fix here is simple. Use the USCIS early filing calculator. Use it twice. Then have someone else verify it. Do not rely on memory or a rough estimate for something this important. But here's where this becomes critical. Even if you file on the right date, you still need to understand what happens between filing and interview. And that brings us to mistake number 2. Processing times for the N-400 are not uniform across the country. This is something most people don't realize, and it makes a significant difference in your planning. As of March 2026, the national average processing time for a naturalization application is somewhere between 5.5 to 9.5 months. That's a very wide range, and within that range, where you live determines a great deal about how long you wait. Field offices in cities like Denver and Houston are currently processing N-400 applications at the longer end, closer to 9 months or more. Meanwhile, applicants in cities like Miami are seeing processing times closer to 6.5 months. Now, why does this matter? Because the "don't wait" message isn't just a motivational phrase, it's a strategic reality. USCIS backlogs are not predictable. A policy shift, a staffing change, a surge in applications, any of these can stretch a 6-month estimate into a 12-month reality almost overnight. If you are eligible to file today and you wait 6 months just to see, you may have added a year to your total wait time without realizing it. The backlog you walk into 6 months from now could be significantly larger than the one that exists today. File when you are eligible, file correctly, and file as soon as you legally can. There's one detail most people are missing when it comes to processing times, though, and it has nothing to do with when you file. It has to do with what's in your travel history. Let's talk about mistake number 3. This one catches people completely off guard, and I want to explain it carefully because the consequences are serious. Under U.S. immigration law, maintaining lawful permanent resident status requires something called continuous residence. For naturalization purposes, that means you must have physically maintained your residence in the United States for the required period, 3 or 5 years, without an extended break. The threshold that USCIS uses to presume that continuous residence has been broken is 180 days. That's 6 months. If you took a single trip outside the United States that lasted more than 180 consecutive days, even once, USCIS may determine that you abandoned your continuous residence, and that can reset your clock entirely. Now here's the 2026 update that makes this especially important. The integration between CBP, Customs and Border Protection, and USCIS has become significantly more sophisticated. Officers now have near-instant access to your full travel history. The idea that a long trip from several years ago might slip through is simply not how it works anymore. These records are cross-referenced automatically. If you had a trip that was close to or exceeded 180 days at any point in the last 5 years, do not assume it won't be flagged. Talk to an attorney before you file. There may be exceptions and arguments available to you, but you need to go in prepared, not surprised. Let me give you a realistic example of how this plays out. Imagine a woman. Let's call her Fatima. She's been a green card holder for 4 years. She's a model resident. She works. She pays taxes. Her children are U.S. citizens. In 2022, her mother fell seriously ill abroad, and Fatima stayed to care for her for 7 months before returning to the United States. She files her N-400 in early 2026, thinking everything is fine because she's been back for nearly 4 years and has had no other issues. At her naturalization interview, the officer flags the 2022 trip. Because it exceeded 180 days, USCIS presumes her continuous residence was broken. Her application is denied. She now has to restart her 5-year clock from the date she returned. Fatima did nothing morally wrong. She cared for her mother. But the legal standard doesn't weigh intention. It measures days. And this is the kind of outcome that can be avoided with proper legal counsel before filing. If Fatima had spoken to an attorney beforehand, she may have been able to file a rebuttal, document the circumstances, and argue for an exception. But once you're at the interview and the denial is issued, the process of recovery is much harder and much longer. Know your travel history, count your days, and if there's any question, ask a professional first. Now we reach mistake number 4, and this is the one I warned you about at the beginning of this video, the one people don't find out about until it's already too late. In fiscal year 2026, the Department of Justice has elevated denaturalization, the legal process of revoking U.S. citizenship, to a top enforcement priority. This is not a minor policy adjustment. This represents a significant shift in how the federal government is approaching cases where it believes citizenship was obtained through fraud, misrepresentation, or concealment. What does that mean practically? It means that if you obtained your green card or your citizenship by omitting or concealing information, a prior deportation order, a different identity, a criminal matter, AI-driven review tools are now being used to re-examine those cases. The government has access to historical records that were not fully digitized or cross-referenced 10 or 15 years ago. They are being cross-referenced now. This is not about targeting good-faith applicants who made a minor paperwork error. This is directed at cases where there is evidence of deliberate concealment. But the important lesson for everyone watching is this: if there is anything in your immigration history that you are uncertain about, anything that you were not fully transparent about at any stage of your application process, now is the time to speak with an immigration attorney, proactively, privately, before USCIS or DOJ reaches out to you. The legal concept here is straightforward. Citizenship obtained through fraud is void from the beginning under federal law, and the statute of limitations on denaturalization proceedings has been extended in recent years. Time does not protect you the way it once might have. However, this protection may not be permanent for those in gray areas. The legal environment is shifting, and the best position to be in is one where you have already addressed any concerns with qualified legal counsel, rather than waiting for a government notice. So what do you do with all of this? Here's your concrete action plan. Step 1. Determine your exact filing eligibility date using the USCIS Early Filing Calculator. Do not estimate, do not guess. Use the official tool, verify it, and confirm it with a professional if you have any doubt. Step 2. Audit your travel history for the past 5 years. Write down every international trip you took, the date you left, the date you returned. Calculate the total days for each trip. If any single trip approaches or exceeds 180 days, do not file without speaking to an attorney first. Step 3. Check your local USCIS field office processing times before you file. Processing times are updated regularly on the USCIS website. Know what you're walking into so your expectations are calibrated correctly. Step 4. Review your application history honestly. If there is anything in your immigration record, any prior application, any prior order, any prior identity or name issue, consult with an attorney before filing. Do not assume it won't surface. In 2026, the tools being used to cross-reference records are more powerful than they have ever been. Step 5. File as soon as you are legally eligible. Don't wait for the perfect moment. The backlog is real. Processing times fluctuate. Filing early, within the legal window, is always the right strategy. Let me give you the broader picture of where immigration policy stands right now. The current enforcement environment reflects a significant shift in priorities at both the USCIS and DOJ levels. The focus on denaturalization, the increased use of AI in case review, and the continued pressure on field offices to reduce backlogs, all of these are happening simultaneously. That creates a landscape where being proactive is not just good advice, it is genuinely protective of your legal status. Court challenges to some of these enforcement postures are likely. There are always legal debates about the scope of denaturalization authority, about due process requirements, and about the administrative procedures that govern how these cases are reopened. But court challenges take time, sometimes years, and while those challenges are being litigated, enforcement continues. The realistic timeline for the current policy environment suggests that these priorities are unlikely to shift significantly in the near term. The structures that have been put in place, the interagency data integration, the AI review systems, the DOJ enforcement posture, these take time to dismantle even if political winds change. The conclusion is practical. Do not assume that the environment will become more forgiving before it becomes relevant to your case. Act within the current reality. I want to close with something important. Your immigration status is not just paperwork. It is the foundation of your family's future. It determines whether you can stay in the country where your children are growing up. It determines your ability to work, to build, to plan. It determines whether you can travel freely and return home without fear. It determines the arc of your life here. The mistakes I described today are not exotic, rare edge cases. They are happening right now to people who worked hard, followed the rules, and simply didn't have the information they needed at the right moment. That's what this channel is for. You deserve accurate information. You deserve to understand the system you're navigating. And you deserve to make decisions based on facts, not rumors, not panic, not outdated advice from someone who hasn't looked at the current data. Stay informed, stay prepared. And when something is this important, talk to a qualified professional. If you want accurate, fast, and reliable immigration updates, subscribe to Raymond Crivello right now and turn on notifications. Immigration policy is changing rapidly, and staying informed is no longer optional, it's essential. Drop your visa category in the comments below. I read every single one, and it helps me understand what topics to cover next. If you know someone who is in the naturalization process right now, share this video with them. It could save them a significant amount of time, money, and stress. And if this video gave you clarity, give it a like. It tells the algorithm that factual immigration content matters, and it keeps this channel growing. I'm Raymond Crivello. I'll see you in the next one.